Hello.
Hello. Good morning.
Hi, David. Welcome to this segment of King County Law Library's What to Expect When video series. Our expert today is David Cedarblade, a Seattle practitioner who's going to talk about the ins and outs of protection orders. Welcome, David. Thank you.
Hi. Thanks for having me.
So, David, it's my understanding that, like most court processes, protection orders start with a petition. Can you tell us a little bit about that?
That's right. So there's different kinds of protection orders. Basically, you can ask the court to limit someone's ability to contact you or to go certain places, do certain things, but you have to have a legal reason to do it. And there's a couple different ones. Most commonly, that might be like domestic violence or unlawful harassment, possibly sexual assault or a vulnerable adult. There's also extreme risk protection orders that you can ask that someone have to surrender firearms, and stalking as well. So each of these have a similar sort of court structure with how the cases go, although the facts in them are different. So as you asked, they start with a petition, and a petition is a mandatory court form that you can get from the King County Superior Court. Also, the state court's website has forms on it. What the petition does is provides the judge or the court with information about who's involved, who is the petitioner, the person asking for help, and what is it that they're asking. Also, what is the reason that they're asking? The what is the reason part comes in a portion in the middle of that form that asks you to describe why you're seeking an order. You can complete that in that portion of the actual form itself, or if it's easier for you to do it separately, you could attach a declaration and write your information that you want the court to understand in a declaration. And a declaration, I know sometimes people get intimidated by many court forms and all these things. A declaration is only, and this is all it is a written statement that says that someone's saying it and they swear under penalty of perjury under the laws of the state of Washington that the foregoing is true and correct. You got to sign that, write where you were when you signed it and what day it was, like signed by David Cedarblade on October 20th in Seattle, Washington. And if you have that information in the special words for swearing that it's true, then that is a declaration, right? So that's just information instead of live testimony in court that in some civil cases, the court will consider as testimony that's given in court. So that's the information that if you don't tell the judge, they won't know, and that's how you tell them.
Great, thanks, David. So we've selected the type of protection order we believe we need for our circumstances, and we've filed our petition appropriately. Now we're on to a hearing, right?
Right. So when you file that petition with the court, the judge or whoever receives it, it'll be possibly a commissioner or a judge, depending on which court you go to. They will review the petition. And if after that review, they find that there is sufficient evidence that an order would issue after a full hearing and that an emergency exists, they can put out a temporary order with the restraints that you asked for. And that order typically will last for 2 weeks. And after 2 weeks, there will be a hearing where both sides can appear and present their side of the situation. The petitioner, who's the person filing the petition, and the respondent is the person that's responding to that petition and seeking to not be restrained. So the hearing can only happen if the temporary order and the notice for the hearing are served upon the respondent with sufficient time. In some of these types of orders, there's a specific time limit set in the statutes. Usually that's 5 court days before a hearing. But I would check the specifics for your case before making sure that you know how far out someone needs to get served. Sometimes it can be hard to serve someone, especially if you're having a dispute with that person or you don't want to have contact with them or you don't know where they are. There are ways to ask the court to be able to serve them in a different manner. Usually, you'll still have to attempt service in person before you can make that request to the court. you could ask the court, for example, at that hearing, say you get your petition, you file it, they grant your temporary hearing, and they set out a hearing 2 weeks later. You come to that hearing in 2 weeks, and I think that a lot of courts, that hearing would be by phone or Zoom, and you appear in the court, and the other person's not present. The judge might tell you, we don't have proper service, so I don't have authority to do anything today other than set another hearing. I know that this can be frustrating when you're seeking the court's protection, but the court is limited by the authority that it has, and it only has authority after proper service. So if you're unable to serve, you can ask the court for leave or authority, permission to serve the other person in a different way, perhaps by mail at their last known address. A lot of times a court will not grant that request until there's been 2 attempts to serve person in person, serve the respondent in person, but I don't know that that's a hard and fast rule. If you can show sufficient evidence that they're not going to be served or they're hiding from the process servers, anything like that, you can make that request. But unless the court grants you authority to serve by mail, you have to serve in person. The sheriff's office in King County will also provide service in some of these matters, but I would suggest that you speak to them directly about it, and don't assume that things will be served just because the court granted your temporary order. You need to make sure that you follow up on that, because that's what allows the court to consider the full order of a year or more.
Now, David, we talked a little bit about temporary orders, which go into place, and then also there will be an order, permanent order or a full order. What about emergency orders in this situation? How do they
Right. Yeah, thank you. So the temporary order I'd say that in an emergency order, in these type of protection order actions, a temporary order is the emergency order. It's the same idea. It's because there's an emergency, we need an order without notice to the other person, but they do get a chance to respond just in court and not, they have to abide by whatever the terms are before that happens.
So hence the second hearing where we actually get a chance to give evidence.
Right. Exactly. And sometimes courts will call that a full hearing. So, the terms that are used can kind of change between courts and what the regular practices are, but a full hearing or a full order is usually as opposed to a temporary order, which, like we said, is usually 2 weeks.
So if I'm a petitioner and I go in to present my argument and I just want to tell the judge what I believe has happened and why I need this order, there's a concept that the judge is bound by called preponderance of the evidence. Can you tell me what that means?
Absolutely. So a preponderance of the evidence is a fancy way of saying more likely than not. It just means 50% plus a little bit. There's a commissioner in Snohomish County Superior Court that I've heard many times describe it as thinking about a football field. And if you're at the 50-yard line, you have not passed the preponderance, but if you fall right on the other side of it, you're past the preponderance. So it's more likely than not. If they're equally true, then you have not met your burden. It's not beyond a preponderance. It's equally true that it could be this or it could be that. So if 2 people come in and give opposite descriptions of something that occurred, it's up to the judge. They have the unenviable task of deciding which one of those things is more true. That is why I think it's very important when you write your petition to include as much information about what happened as possible. People will often ask me, what's the perfect evidence? What do I do? How can I prove this? And that's essentially there is no perfect evidence. If you have any sort of documentation or information from third parties that are objective, you can have a declaration written by someone else be considered as part of either your petition or responsive documents to the petition. You can also include other documents as long as you identify what those are in your petition or in your declaration. So if there's other information you want the court to know, just remember, unless you file it with your petition and serve it on the other party, it's not going to be considered. And that's the stuff that the court will look at to decide whether it was more likely than not that, for example, domestic violence has occurred, or more likely than not that unlawful harassment occurred, or that there's abuse of a vulnerable adult, right? Any of those things, the court has to decide that it's more likely than not that they happened before they will grant that order.
And is this standard the same across all types of protection orders?
Yes, that's a good question. It's the same standard for a full order. It's more likely than not standard.
Okay. So let's assume that the judge finds, or the commissioner finds, a preponderance of the evidence in my favor, and there is an order now. And what are the mechanics of that, and what does that really mean?
Yeah, so there are, like we talked about, the different types of orders might have different restrictions like inherent to them. Most specifically, the extreme risk protection order only has to do with people's access to firearms. The other ones can have limit people's ability to have access to firearms if you have proved sufficient information to the court to support that finding. A court could order that a respondent surrender and not possess any firearms for the length of the period of the order. They can also limit your ability as a respondent to contact the petitioner, or only contact them in certain ways, not go to their home, their business, their school, their place of work. If there are minor children, in some circumstances, someone can petition for protection of their minor children as well. If they are the respondent's biological children, there are more restrictions that come into play. For example, you can't seek an unlawful harassment order involving the biological children or the children of the respondent in district courts, only in superior court. So that's something you need to go to superior court, not for any of the district courts for. Also, if it affects a respondent's ability to have communication and contact with their children, that those orders can't be more than a year in time. That is because the court wants, especially if there's a parenting plan in place, right, the respondent should have an ability to reassess this more frequently than they could otherwise. In cases when that's not true, the petitioner can ask the court to have an order for longer than a year, but they have to make the special showing, and the court has to agree that the respondent is likely to engage in acts of harassment or domestic violence or stalking, whatever it may be, if the order is only a year in length. So there's got to be some other information to show that a year is not going to be good enough. And that can be a difficult showing to make, especially if there's never been an order between those people before.
Okay. So is it true that depending on the protection order, you might be in district court or superior court?
That is true. You have the both superior and district courts have jurisdiction and authority to hear these matters. I would contact the specific court that you're considering going to. I know that for example, King County Superior Court has a really good website with all the protection order information in one place, and the paperwork that you would need to complete for each of the specific types of orders that you might be considering seeking. I know that the district courts can hear these, but I wish I knew more about what their website is as far as whether you can do the same things there. But I know that they have authority generally to hear these, with some of the exceptions that I mentioned involving children. Also, I think that just popped in my mind is something that had happened in the past is if it's limiting someone's ability to enjoy live in their home essentially, then that's another one that usually can't be heard in the district court, but has to be heard in the superior court.
Okay. It's very good to know, because people get confused about which court to approach to begin with.
Absolutely. The general question is if for jurisdiction to be proper in a certain county, you have to show that either the petitioner lived in that county when the alleged harassment or violence or whatever it was occurred, or that the respondent lives there, or that the petitioner had to flee to that area because of the reasons that they're seeking protection order. Another one that comes up is if there's like telephonic or internet, some sort of remote harassment where you're not in the same place. The question for the court about where it can go is where the person receiving the correspondence is. So if I live in Seattle and I'm getting crazy harassing emails from someone in Boston or San Francisco or Kansas City, I can still get protection here in King County because I'm receiving those communications here, regardless of where that person is. Serving them out of state could be more complicated, but you have the authority to go here.
That's very good to know. Okay, so I've filed my petition. I've had at least one hearing, probably two, and there was an order issued in my favor. Does that order exist from now in perpetuity, or when does it end and what ends it?
Good question. Yeah, the order on its terms will list the duration. Like we talked about, usually that's a year. It could be less. It could be more than that if there's certain showings made. The courts do have authority to issue permanent restraining orders, or permanent orders of protection, excuse me. And while that's rare, it's not unheard of by any stretch, and it does happen. If there has been some other reason for the parties to be involved, or there's been other court involvement between those two people, it's more likely, I think, that the court might issue a longer period of protection. But it should say on the order itself when it starts and when it ends.
And what if I want to renew the order? What if the situation hasn't really changed?
Right. So say we go to court. I'm just making easy math here. November 1st this year, I get an order for protection that says that someone can't communicate with me. I think it's within the last 3 months, and I can check the statute on that. But before the order ends, you can file a petition for renewal or a motion for renewal. And you have to serve that motion and request on the other party and file it with the court and note the hearing and do any other administrative things that you might need to do to get that hearing set. But in a renewal hearing, there's a different set of questions for the court to answer. When you seek your petition, your job is to prove that it's more likely than not that the thing you're saying happened and that violated the statute. In a renewal situation, say I go October 1st next year, I file my petition for renewal, I serve it on the other party. We go to our hearing on October 20th, and it's just before it's about to expire on November 1st. At that point, the respondent has to prove that it's more likely than not that they will not continue to engage or re-engage in the type of conduct that led to the order being entered. That's a very difficult situation as a respondent, and I can say that, having represented people in those hearings, to prove to the court that a negative thing is not going to happen is very difficult. So especially in cases that is most common, I think, when there's children involved between the parties, court might be looking for proof of some sort of treatment or counseling that might be sufficient to assuage their concerns. Sometimes that's specifically laid out as some of the restraints in the order for protection that if there are two parents, one of the respondent has to complete a domestic violence assessment or treatment or something to that end before the court will consider lifting it. If that information is lacking from the order, it's up to you as the respondent to explain to the court why they should lift the order. And if no one takes any action to try to reissue the order to renew it, then it'll end on its terms.
Great, thank you. Well, we all know that the COVID situation has affected just about every court process that's out there in one way or another. Can you give me an idea or some information about how COVID may be impacting the protection order process?
Yeah, it does. It's changed major ways about how the petitions are accepted in most places and considered by the court, and also how the full hearings that we talked about are held, or some of those renewal hearings, same idea. That I mentioned a King County website, and I'm told that the law library has excellent tech services that will make this magically appear while I'm talking about this.
He's right.
But if you go there, if you go there, you can I believe you can file your petition directly through the court's website now, which is new and makes it easier if someone is seeking a petition. The return hearing, I believe that the initial review of the petition is administrative by the judge, and that they don't ask you questions about it. They look at what you filed and they decide about the temporary order and when the full hearing will be. The full hearings, from what I understand, each court is different, so I suggest you contact the court specifically, but the vast majority of courts are hearing these remotely, possibly through Zoom, like we're having our conversation today. If you don't have the technical capability to appear by video, I think there's ways to do that through phone contact as well. So those are the two biggest changes, is the way the hearings are heard and the way the petitions are filed. My biggest advice on these things is to check with the court about what their specific procedures are before you start to file your action or get ready to go to court.
Yeah, do your homework first.
Right.
Well, thank you very much, David, for sharing your time and your expertise. And we learned a great deal about protection orders, and hopefully our listeners will be able to do things a little more successfully and appropriately with the courts.
Exactly. And one more resource I always give to
Absolutely.
is it's a really good website. It's not just about this topic, but WashingtonLawHelp.org has tons of information about protection orders and how COVID is affecting court procedures. Also, there's family law, landlord-tenant issues, cleaning up criminal records, lots of good stuff that people might need help with. I suggest to look at that instead of trying to remember all the things that I just said here.
Well, David is exactly right. Everything that he's talked about in terms of website references and additional materials follows at the very end of this Zoom interview. Thanks again, David. Appreciate you being a talent for us on what to expect when.
Oh, this is fun. I hope it's helpful.